Islam.
All right, so we're going to keep it moving. We're going to keep it cranking, Mose. And so today, my demonstration is going to be pertaining to two correlating subject matters. I want to talk about jurisprudence, and I want to talk about jurisdiction, but from the Moorish perspective. Because, we hear a lot of terms thrown around in the Moorish movement. And when I say a Moorish perspective, let me be clear. When I say Moorish perspective, I'm talking about specifically from the Prophet Noble Drew Ali's vantage point. Although I may reference other Moorish groups that, splintered and have different paradigms. I won't reference the group, but I'll reference the doctrine to kind of bring clarity on it, because you hear like catchphrases. You hear, natural law. You hear the word jurisprudence being thrown out of there. You hear the word jurisdiction and how they don't have jurisdiction over the Moors. And all these concepts could kind of be elusive if you don't really have a foundation or know where to look to get an understanding of that. So Islam, I guess Brother Devin, he could be my reader. So if you want to bring the chair a little closer. Just this line right here, the Free National Constitution, up until, go ahead.
Islam. The Free National Constitution law that was in... We're reading a divine warning about a prophet for all nations from the Prophet Noble Drew Ali. The Free National Constitutional law that was in force since 1774 declared all men equal and free.
So the Prophet makes a statement. He says, the Free National Constitutional law. Is he talking about what we call the United States Constitution today? Yes and no. He's not talking about the version during the time after the American Revolution and all that. 1774 precedes, it's before the American Revolution, okay? It's before the Declaration of Independence. But he says that all men were declared equal and free in 1774. Well, we all know, behold these truths to be self-evident, that all men, et cetera, from Thomas Jefferson, right? But what is this? He says 1774. So what legal document is he referencing? Well, let me let him finish reading that. But remember, equal and free, all men are declared equal and free in 1774. I'm gonna let him finish reading the excerpt, just for the sake of clarity.
And if all men are declared by the Free National Constitution to be free and equal, since that Constitution has never been changed, there is no need for the application of the 14th and 15th Amendments for the salvation of our people and citizens.
Islam. So that's a very important perspective right there. The Prophet says all men were declared equal and free in 1774. Hold on one second, Moors. So I want to pull something else up too. Oh yeah, that's fine. I disabled my thing. Okay. So can we find any historical record in 1774 pertaining to this? Well, we could first look at a pamphlet that was published by Thomas Jefferson in 1774. It's entitled A Summary View of the Rights of British America in 1774. Now this was a draft that was submitted in Virginia, but it was for the convention. It was for the first Continental Convention, this particular document. And I'm gonna need a reader just to read this excerpt right quick. Hang on one second, I gotta find where I put the line at. So could you read, should we read it from the top? I guess we have a few minutes. We can read from the beginning. We'll just read up until I tell you to stop, which is going to be right here. It's long.
It's long. Resolve that it be an instruction to the said deputies, when assembled in General Congress with the deputies from the other states of British America, to propose to the said Congress that an humble and dutiful address be presented to His Majesty, begging leave to lay before him, as Chief Magistrate of the British Empire, the united complaints of His Majesty's subjects in America, complaints which are excited by many unwarrantable encroachments and usurpations, attempted to be made by the legislator of one part of the empire upon those rights which God and the laws have given equally and independently to all.
Stop right. Read that last part again. Upon the what?
Upon those rights which God and the laws have given equally and independently to all.
It's long. So the prophet said equal, that all men are declared equal and free. So when you read the rest of this document, it's basically, as it was read by the Sheik, enumerating the various complaints that the subjects of the British Empire inhabiting the Americas had with the crown. Okay, so this is when the United States of America is first forming. Okay, so that out of that Continental Congress and out of that particular document, among other areas we're going to get into, Thomas Jefferson derived some of the language and concepts that went into the Declaration of Independence. But that's just a little tidbit for y'all Moors, like, 1774. You got to actually take these dates and look at them, because the prophet is not off with his mathematics. Okay? We know the Declaration of Independence is 1776, but he says 1774. So you have to look at the year 1774. And what's egregious for us as Moorish Americans not to do is to not Google it. The prophet says, you know how I got this information? I Googled all men equal 1774. And I just went through the different links, And then that's how you get information. You can verify or corroborate or find that some things the prophet had claimed is unsubstantiated simply by, doing something that takes a couple seconds.
It's long.
It's long, more. So we're gonna first touch on natural law. All right. So should I define jurisprudence first? Can somebody pull up a definition of jurisprudence? We don't need to get all that complicated. But I didn't list the definition here, but I kind of want to, because we use the term jurisprudence, but what does it mean? Moors use the term jurisprudence in the context as if it's superior to law, or it's some higher form of law.
Isn't the definition true law?
Islam. Say that again?
Isn't the definition true law?
No, you're asking if in the definition of jurisprudence is true law? No. Islam, that's like, let me see. Yeah. Well, you can just read it. It's real simple. Just read up to where it says.
Jurisprudence. The word jurisprudence derives from the Latin term juris prudea, which means the study, knowledge, or science of law.
Jurisprudence comes from the Latin term juris prudentia, or something to that effect. The study, knowledge, or science of law, right? That's where the term is derived from. But you don't just stop there in terms of the etymology of the word. You have to continue to get the connotative or the modern meaning of the term.
In the United States, jurisprudence commonly
because he's reading it separately. In the United States jurisprudence, because jurisprudence isn't perceived the same all over the world. The United States of America has its own form or version or interpretation of jurisprudence. All right, so just want to make note of that.
In the United States, jurisprudence commonly means the philosophy of law. Law philosophy has many aspects.
So it's the philosophy of law, all right? It's the concepts in a philosophical sense that we're looking at the law, all right? So it's not the letter of the law. We're not looking at, what does United States Code Title 42 say? Section A, subsection, whatever. That is the actual law itself. That is the what you would call the statutory law, or the law itself. We're not looking at the Constitution. We're looking at the philosophy behind that law. You understand? The philosophy, not just behind specific law, but the legal system. All right? So that's what jurisprudence is. So when Moors are utilizing the term jurisprudence as if, it means something in courts, all you're telling the court is, this is my philosophy of law. All right? You're not expressing anything of substance throwing around that term. Okay? So there are various different schools of thought within jurisprudence, or various different philosophical schools. All right, so the school of thought that Moors adopt is what was called natural law theory. Okay, now we're going to get into natural law theory, but there are other schools of thought, and predominantly what you see exercised in American jurisprudence today is positivist law.
Positive law.
Okay, or positive law. So, natural law theory is a philosophy that has influenced the ideas of the founding fathers, right? Who drafted the United States Constitution. So we're going to look at the Declaration of Independence because we see that in that document you see natural law in it. And this is why, again, we're not going to preface to say one particular philosophy is better than the other. We're going to kind of try to understand why Moors are citing natural law. Because in the inception of the United States of America, natural law was what? And we already know that Moors focus on that 1700s period. They don't really look at periods beyond that of any substance. They dismiss it because the rest of that period of American history is de facto. Therefore, we don't have to acknowledge, any precedents that were set or any perspectives of the evolution of the legal system in America, because it's de facto anyway. All right, so we're going to define natural law. And this is from the Encyclopedia Britannica. In philosophy, a system of right or justice held to be common to all humans and derived from nature rather than from the rule of society or positive law. All right, because see, that's profound. Because the prophet is referencing natural law when he's saying in 1774, all men are declared equal and free. How do we know this? Because the author of these concepts, or where these concepts are derived from, we're going to actually look at them. Not only are we going to look at what Thomas Jefferson had to say, we're going to look at who influenced Thomas Jefferson.
It's long.
Where did he get that doctrine from? All right, this ain't going to be a one-part of Moors, so y'all going to have to stay tuned to get all the degrees in this particular lesson.
That's right, Mom.
There's a lot of information I'm going to go through, and I'm not going to rush through it on the simple premise that, it's better or more convenient. Y'all Moors going to have to really do your knowledge to get all this information. Ingrained in the history of the United States is another significant commemorative document known as the Declaration of Independence, right? Written by Thomas Jefferson, as we already stated. So this is what Thomas Jefferson had to state. He said, when in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to separation. So I read that excerpt because he has a reference to the laws of nature and of nature's God, which gives an entitlement to all of mankind. Right? Now, Thomas Jefferson, like many of the founding fathers, were students and products of the Enlightenment period in Europe. It's all correlative, boys, because if history is nothing but cause and effect, right? So if you go to the Enlightenment period, what precipitated the Enlightenment period? What brought about the Enlightenment period? What was the period before the Enlightenment period? Right? You got the Dark Ages in Europe. You have the Moors who come into Europe and educate the European. Teach them the association between health and hygiene so that they stop dying to the bubonic plague, because many of them thought it was a sin to bathe. Many of them lacked hygiene. So Moors built hundreds of bathhouses throughout Europe and literally scrubbed the European. You see how they do it with the coronavirus today? How they come through with the hazmat suits and they quarantine. This is what Moors was doing in medieval times. They were snatching up Europeans and they were scrubbing them. You'll see paintings of this. If you look at you type in Moorish bathhouses and click on images, you'll see paintings of Moors, Moabite sisters scrubbing European women, and you know what I'm saying? It was to again contain the plague that was killing them, right? And then in the Dark Ages, 99% of Europe was illiterate. Even kings and queens could not read or write, right? It was the clergy who were the members of society who were able to read. So it was the Moors who brought about education. Many of the universities and educational institutions that were founded in Europe, the first educators in them were Moors. Places like Oxford and etc. Right? So these were students of the Enlightenment period. So indirectly they were students of Moors. But who were their direct influencers during this particular period of history? After the Enlightenment period. So they studied British history and French history as well as their political philosophies. Many of the founding fathers were acquainted with the works of political philosophers such as John Locke. If you look at John Locke's work, The Second Treatise of Government. Now see, Moors want to talk government, they want to talk, republic this, and they want to talk certain, inalienable rights and natural law. You have to know where this information is derived from, so you have a more pristine viewpoint than as getting it from a secondhand source. There's nothing wrong with reading, literature produced by Moors or produced by Europeans or any other group of people that may have a perspective on this, but getting the original source of the knowledge is imperative to have an understanding. So we're looking at John Locke's work, right? In this particular work, The Second Treatise of Government, Locke professes his subscription to the views of natural law that are consistent with Jefferson's presentation of those ideas in the Declaration of Independence, right? So Thomas Jefferson in the Declaration of Independence, he also said, "We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and a pursuit of happiness," right? So here we go, these unalienable rights, these God-given rights that are bestowed by nature's God, this particular concept, right? So again, that all men are created equal, that concept is 1776, but the prophet says 1774. So that's why the beginning excerpt that I had read, so you can kind of tie this in together with the Moorish literature. But the prophet is well studied. You think he don't study European history? You think he didn't study American history to lead us on a path? We are products of that knowledge.
Islam.
So I couldn't even be here teaching you what I'm teaching you today if the Prophet didn't have this knowledge before me. Islam. So John Locke's earlier conception, this was almost a century before, is so profoundly similar that it is clear that the latter influenced the former. Locke was a known proponent of natural or inalienable or unalienable rights. How we know this? Well, John Locke stated in the Second Treatise of the Government, he said, all mankind being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. This is in 1689. Does that sound similar? Does that sound similar to the language of Thomas Jefferson to y'all?
Islam.
Islam, man, talk to me.
Islam.
Remember, in the 1774 excerpt, right, from the Summary of Views of the Rights of British America, he states that upon those rights which God and the laws have given equally and independently to all. So he put that term independently in there. In this initial original version. But when we look at John Locke's Second Treatise of the Government, we see that all mankind being all equal and independent. Right? It's called the Declaration of Independence, but he didn't use that language. He said that all men are equal and free. He didn't say independent. So the language was changed after he found a more satisfying way of relaying that concept. But that equal and independent you find in John Locke's work in 1689. So it is clearly indicated by the concepts and similarities between the Declaration of Independence and the Second Treatise of Government that the ideals of natural law has partial but significant British origins and reverberating implications in the founding of the United States of America and its political culture and national civic philosophy. So kind of referencing, Grand Sheik's demonstration last week when he was tying in, saying, about Ezra and how, the Torah was influenced by Babylonian writings, the Code of Hammurabi, right? And how it has foreign influences, whatever. The United States Constitution is similar in that regard, where he was explaining how, you had the indigenous Moors with the Great Law of Peace that were influencing. You had the British governmental system. You had the French. You had, ancient Greece. Various different influences came to be what was known as the American Constitution. And many different authorities were consulted. So this is what the Continental Congresses was about, okay? They wrote different documents, right? Declaration of Independence was one. I gave you another one, which is the rights of, a summary of the views of the rights of British America, right? You also had some very significant, which was called the Federalist Papers. Alexander Hamilton, right? James Madison and the like. So they wrote documents based off of their studies, and they reference periods in history and other works within their works. But sometimes you have to do the knowledge to connect the dots, because Thomas Jefferson doesn't reference John Locke in his writings. Okay? So you would have to be familiar with what the colonists were reading at that time to kind of know that John Locke was an influencer, right? So a very important aspect in natural law in American government is the concept of the social contract, right? Because this is what's important about us, about Act 6, about us proclaiming our nationality,
That's right? That's right.
Before the government, because what the European is operating off of in terms of us being Negro, black, and colored and our rights, etc., it's called a tacit, T-A-C-I-T, agreement. Meaning, they calling us black, they calling us African American in schools, they putting it on our census records, they're identifying us, on our court papers and documents as African American or black or etc. So by us not saying, no, that's not correct. You have me misclassified. We're tacitly or silently or acquiescing, we're tacitly agreeing to be Negro, black, and colored as a people. and as individuals, because we're not saying anything to the contrary. And when they treat us accordingly, it's based off of the tacit agreement, right? Well, social contracts are very similar to that ideology, right? So there are a number of other important historical figures from Europe that were proponents of natural law theory, and also influencers of the founding of the United States of America. See, you have Moors using language. What are the origins of it? Okay, so you can't talk about natural law theory if you're not talking about the Enlightenment period, and you're not talking about the European philosophers that came out of that Enlightenment period. You could be talking about natural law theory in a more ancient context. Maybe you could, tie it in that way. But in terms of it being coined, this particular term, in terms of its influence on the United States Constitution, we're talking significantly influence from Europe, significant influence from Europe, because during this particular time, a lot was going on, okay? A lot was going on. The French and Indian War took place in the Americas, right?
Islam.
So who was fighting?
French and Indians. British and the French.
See, you caught yourself.
Yeah.
The French and Indian War wasn't just a war where the French was just fighting Indians in America. The French and Indian War was just called that, but it was Native Americans, Moors, indigenous people on both sides fighting. It was the French fighting the British and their allied indigenous folk versus the French and their allied indigenous folk. So things that were taking place in the Americas had international relationships and consequences. Okay? So you can't study Moorish history if you're not studying European history. All right? They're intertwined. You can't study Christian history or you can't study Muslim history without studying Christian history. They're intertwined. You can't talk about the Muslims if you ain't talking about who they fighting. All right? So we got several centuries of history so these things are correlative. So there were other revolutions that took place contemporary to the American Revolution, right? So there was a French Revolution as well. The French and American Revolution, they held steadfast to the principles of individual, natural, or unalienable rights that British colonialism and French monarchical despotism contravened. What do I mean by that? Right? The French and American ideals that the individual, because you have to understand, there was a period in American history in global history where you had serfdom, right? Where in Europe, the landowners were the nobility, right? This is where you get the term landlord from, right? So when you go rent a place, right, you don't own it, right? The landlord owns that place, and you pay that landlord to stay in that place. Well, it was a little different where you didn't have no land for yourself to farm. So you lived on a land that belonged to a noble, and that land forever belonged to that noble. So regular people essentially couldn't own land, right? Regular people were relegated to a perpetual serfdom or perpetual servant class, right? So that's what I mean by and we already know what British colonialism, but that's what I mean by the French monarchical despotism, right? There was no social mobility, upward mobility, right? You were basically born into your caste, right? And then the French Revolution and the American Revolution led to a shift in that thinking and a shift in how the people wanted to be governed. So now they're saying, nah, just because you were born a prince or a king don't make you greater than me. We were all born through the grace of the Creator, right? Nature's God or what have you. And we are all afforded those same rights. So contemporary political thinkers of that period, like a man by the name of John Rawls, right? Thomas Hobbes, Jean Jacques Rousseau, they all promoted the concept of the social contract. The idea is the belief that the only way to legitimately possess political power over others is to obtain consent from the governed. Okay? Y'all more following me?
Islam.
All right, so basically the people have to agree for you to be in power over them, for you to have authority over them, right? And that's what's called the social contract, right? So social contracts are based on the classical liberal principles of government. And this was used by American founders to justify the American Revolution. That same principle or concept of social contract, no taxation without representation, right? It's very similar ideals. All right, so let's move on. So many accounts of the origins of the American Revolution recount the discontent with British colonial rule that was viewed as unjust. So social contract theory gave rise to the notion that a government cannot have legitimate de jure rule over subjects or citizens unless there is a social contract or some form of consent given by the government. This justification was paramount for distinguishing between a revolutionary versus a terrorist against the state. All right? A very important concept, right, that we're going to explore later in reference to sovereign citizen ideology when we get to that portion of the demonstration, which won't be this week. We only got a few minutes left. So as most of my demonstrations, they build up to a crescendo. So I'm providing certain basic knowledge that's gonna, give us a better concept of everything that I'm talking about. Because again, now I'm focusing this portion on jurisprudence. We get into jurisdiction once we have a better understanding of natural law, social contract theory, all of these things that kind of create the basis by which, when Moore's using the language, next time somebody talking natural law, you're gonna have a basic knowledge of what that means. The basic knowledge of the origin of that. Because, again, it's a lot of buzzwords. Sovereign this and natural law that and jurisprudence this. And these words are not commonly used in our community. So nobody ever took the time to sit down and break this information down. So that's what we here to do in our Sunday school. Islam?
Islam.
So I have a section dealing with Thomas Hobbes in the social contract theory. We're gonna look at John Locke again. I like to look at John Locke. He was a huge influence, and he has some very profound ideas that influence not just how government is run, but also capitalism. The concept of capitalism, laissez-faire and all that. Like John Locke had a lot to do with our concept of these things. So Locke perceived man's natural state as sublime, right? What he viewed as a major problem with the natural state of man was the absence of the protection for private property. According to Locke, the need to secure personal property was the motivation for the innovation of the social contract. Would y'all agree with that or disagree with that? Let me repeat it.
Gotta repeat that.
According to Locke, the need to secure personal property was the motivation for the innovation of the social contract. Was the reason why that idea came up, to protect private property. So what am I asking y'all? We decided to band together and form a government because we want to protect our private property. This is his theory. It's not right or wrong answer. You agree with him or you could disagree with him. But this is the basis of, this is his argument.
Yeah, I see where you're coming with it.
Okay.
This is only right if you acquire property, right? You want to hold on to it.
Right, you could view it to the extension of your family, your food, water, provisions, All of these things, like, think about it, you're in a tribe, right? And, you know, you got some brothers in the tribe and they out there hunting. Who's protecting the women and children and, you know, all our resources? You know what I'm saying? It'd be other men in the village. And they all agree to the social contract. All right, I'm a hunter, this guy's a fisherman, this guy's a guardsman. You know what I'm saying? And that's how we're gonna do it, how we're gonna be able to govern ourselves. Right? So that's kind of the idea, the basis. A major difference between the Lockean and Hobbesian views, actually I might well go into that because I didn't go into the Hobbesian, so I'm not gonna, or Thomas Hobbes, so I'm not gonna go into that. All right, we're gonna skip a little further. So Locke was quoted as saying, "The end of government is the good of mankind, and which is best for mankind, that the people should always be exposed to the boundless will of tyranny, or that the rulers should be sometimes liable to be opposed when they grow exorbitant in the use of their power and employ it for the destruction and not the preservation of the property of their people." So the impact of his words pertaining to the right to abolish or change government can be clearly understood in the Declaration of Independence. All right, so we can see another example of Locke's influence. He said that Thomas Jefferson states that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its power in such form as to them shall seem most likely to affect their safety and happiness. So it's very important to see that the ideas, we're going into the philosophy of the founding fathers. We're going to the philosophy of American jurisprudence. Okay? So, see, and this is the thing that Moors do. They'll be like, all right, well, you know, jurisprudence, like you was reading the definition, whatever, jurisprudence, that means the science of the law. And if you do the etymology of it, you actually, you know, go to the Latin, then yeah, that's the literal translation of it, but that's not what jurisprudence means. It's not the science of law, it's the philosophy of law, you know, in terms of how it's practiced in America. And worldwide. So this is what I'm saying, like, Moors, don't be fooled by parlor tricks, man. Little magic tricks. Moors use a wordplay. They're not really who breaks down what jurisprudence is? Giving you example of jurisprudence. Showing you application of jurisprudence. Don't just let Moors throw words at you and you get impressed. Islam?
Islam.
So an important focal point for Locke is the right to property, as I stated before, which he considers a fundamental and foundational principle of social contract theory. So the right to property is proverbially born from the labor that man performs with his hands using the resources of the planet. So I'm kind of break this down, because it's not just, you know, you have a right to property, period. So basically to that logic, right? Before mankind utilized his labor, he had no entitlement to any property, because God created the earth. How could you have entitlement to something that you didn't create, that you didn't put there? How is it yours? Right?
Islam.
So to give an example, right? If someone were to discover an apple tree in the woodlands, they could not claim the tree as their property according to Locke's views, because they had no role in the creation of that tree. Right? Conversely though, if that individual took seeds from that apple tree, from the apples that they ate from that tree, and then planted a vineyard, right? Planted a bunch of apple trees, then that person would have property rights to the apple trees that they planted. Make sense?
Islam.
That's the man using his own efforts, using his own energy, using you know, the force of life that Allah put in his body to manifest that which he claims to be his. So the framers of the Constitution gave significant emphasis to the protection of property. Now, we can go into another tangent where why they were so adamant about protection of property, because many of the signers of the many of the signers of the Constitution were very wealthy. Okay? And it was said that they had concerns of the less wealthy taking their stuff. You know what I'm saying? So they paid a lot of attention to property rights for that reason. Right? So let's take a look at the Bill of Rights for a second, right? The Fifth Amendment. No person shall be deprived of life, liberty, mind you, I'm skipping out some words, but no person shall be deprived of life, liberty, or property without the due process of law, nor shall private property be taken for public use without just compensation. So the Fifth Amendment references property twice. He uses the term property twice. It's saying that you can't even take a person's property. Why is this here? Because in Great Britain, under the French monarchy, they could take your property. Private property was taken. Okay? So, in order to prevent the government from becoming too tyrannical and start taking people's stuff, they have to follow what's known as due process of law to take your property. And then even when they do, they can't just take it. They gotta pay you for it justly. Okay? But this is right out of Locke. This is right out of John Locke, who lived almost a century earlier. As a matter of fact, the Fifth Amendment being drafted in 1789, the Second Treatise of Government was 1689. It was exactly a century later that we see these clauses being added. So basically, according to the Fifth Amendment, the government has an obligation to protect the property of citizens. So part of the clause reserves the right of government to take private property under the condition that it is for public use. Okay? So they couldn't even just take your property just off the strength that the government wants it. It has to serve some public use. Right? So under that specific and limited condition, the government was required to compensate the property owner fairly according to the value of the property that was taken. Now Hobbes, we were talking about Thomas Hobbes earlier, I didn't go into his section, but Hobbes had a significant influence on the philosophy of Locke, but viewed the social contract as a means to secure the natural rights of life, liberty, and property. So they disagreed a little bit, Hobbes and Locke. And as a result, the enjoyment of the pursuit of happiness can exist for all men. Right, so I think that's enough on the social contract, the motivations for it, etc. So I'm actually gonna start on this topic, but we're gonna close out very shortly. But I want to talk about natural law theory, because there was a decline of natural law theory and then the resurgence. Okay? So when you hear Moores quoting about the natural law theory today, it's based on the resurgence of natural law theory. Okay? That the sovereign citizens wound up picking up on. Okay? These authorities that I'm consulting, these are the authorities the European sovereign citizens consulted to come up with their doctrine to which Moors follow today. Okay? So, cutting out the middleman. We're not even going to look at what these European sovereign citizens are saying no more. Now we're going to look at the actual documents and the primary sources, because we have the technology, i.e. the internet, to look this stuff up. We don't have to go and buy, books that are written by these guys anymore. So two philosophical innovations are considered as the primary variables that led to the decline of natural theory in American jurisprudence. The modern conceptions of legal positivism and non-cognitivism had an insurgence in thought, largely replacing natural law theory. Now remember I talked, so you have natural law theory, you have positive law, legal positivism, right? So what is legal positivism? What is positive law? This is what you see every day in the courts. Do you hear the courts talking natural law to you? Do you think the judges is kicking natural law? No, they're not. They're picking legal positivism. So let's see what that says. According to the Internet Encyclopedia of Philosophy, it can be defined, you could look at legal positivism as a philosophy of law that emphasizes the conventional nature of law, that it is socially constructed, right? So natural law is saying, oh no, the laws of the universe, the laws of the creator, the laws of God, and then that law is delivered through divine hands, prophets and all that, then you have the law of the state or whatever, and then there was hierarchy and all that, right? But coming from the laws of nature provided the laws, and we kind of observe nature and it create laws. Those are the only kind of laws that are just, right? But according to legal positivism, law is synonymous with positive norms. That is, norms made by the legislator or considered as common law or case law. Okay? So when you run in the courtroom talking natural law, and many judges are legal positivists, they're saying, well, you're challenging, why? Well, the Congress passed this law, you know what I'm saying? The New York State Legislature passed this law, you know what I mean? This is what the statute says. All right? That's the philosophy that you are contending with, against, when you are standing on natural law. Okay? I think that the prophet would be amalgam between the two. Right? Because he talks about adherence to the Constitution and et cetera, but he talks about, men being declared equal and free and, different things. Even that can be legal positivism, honestly, because the actual letter of the law itself says that men are declared equal and free. But, so just basically that the social construct of law, like they don't really, it's not about morals or morality or the creator or natural law, it's about the letter of the law, right? So contrary to natural law, legal positivism does not believe that the law is derivative from divine forces, reason, because that's another big premise, or inalienable rights. There is no need for significant moral considerations, and law is the result of social norms, right? So that's the primary mechanism or philosophical thought that you're going to see being implemented in courts today. And there are arguments in jurisprudence that counter each school of thought, right? But in the courtroom, the judge is not going to be arguing with you or your philosophy on law. You understand why it was important more for me to bring this particular subject matter up? Because this is not science. Okay, this is not the science of law. This is philosophy. It's not going to have practical application in court to the extent that Moors utilize this term or terminology, right? So we get ready to close out. Let me just give a couple last thoughts.
Islam,
Moore. You something you want to say real quick?
Yeah, I'm rise to my highest heights, giving praise to Father God Allah. I give honors to all prophets, Jesus, Muhammad, Buddha, Confucius, and the prophet of these last days in time, Prophet Noble Drew Ali. My name is Haram Gideon. I greet y'all in peace.
Peace.
I'm actually reading a book pertaining to ideologies or philosophies from the French and the British. French came to Canada, and the British were they call them like Tidewater, along the coast from Maryland, Delaware, down south. You had the British aristocrats, the rich, and they was with more liberty. And then the French was more of being that they was living and moving with the indigenous Moors, the Indians that was there at that time, and how they was governing themselves. So there was more on equality up north, and then the British aristocrats was more about the wealthy control everything, and the poor basically would be their servants. And that's how they was there. They'll give them liberty, but they won't give them equality when it comes to certain titles and positions. But the French would. Everybody was equal.
Islam. That's kind of dealing with some of the causes of the American Revolution. Okay. 1600s. In terms of revolting against the British and the French allying with America, having similar ideals and all that. But we're gonna close out on that, boys. We'll get back to the resurgence, the decline and resurgence of natural law theory. Then we're gonna get into specific, doctrine of the Moors, dealing with natural law, dealing with jurisprudence, natural law theory, and sovereign citizens and all that, and bring this full circle. We're going to start discussing the basis of the jurisdiction argument, and what distinguishes our jurisdiction argument from other jurisdictional arguments, challenging jurisdiction and stuff like that. And with that, Moors, appreciate your time, and I'm going to close out with that. Islam and peace.
Islam.